Welcome to DRT, Direct Real Talk with the Arizona Department of Real Estate. I'm Assistant Commissioner for Enforcement and Compliance Division, Liz Recchia. This podcast is designed to bring you information and insight into the world of the Arizona Department of Real Estate. The department is obligated to comply with the law and with Arizona Administrative Code. But how the department makes decisions and the considerations brought to that decision-making is interesting and necessary to understand, since the mission of the department is to protect the public interest through licensure and regulation of the real estate profession in Arizona. Join me today as we discuss subdivisions and development services with Tim and Jay. What are the types of developments? Who is considered a developer? And what are the most common questions our development services staff receive? You will learn what a public report is, information the builder or developer must provide in the public report, and how that report benefits you, the consumer. Have you ever wondered what goes into providing the vast amount of information contained in a public report, or wondered what it takes to turn raw desert into a house? Today you will gain insight from the development services staff as to what is required in order for a subdivider to gain approval from the Arizona Department of Real Estate. Okay, welcome to the podcast, and thanks for taking your time to be with me today. Let's start by getting to know you a little bit, what your job is and what development services is. And I would like the audience to know that we are speaking with Tim and Jay.
So my name is Tim. I am a development services specialist, and my main role at the department is reviewing applications for a subdivision public report. I'm also involved in subdivision investigations, which is another part of my responsibilities here at the department.
And Jay?
Yes, hello. My name is Jay, and I'm also a development services specialist with the department. And I have very similar duties as Tim. Basically, we review all public reports and information for development services that comes in to the department.
Okay, great. So development services, is that the same as subdivisions? We hear those terms used back and forth and interchangeably. Is it the same thing?
You know, that's a great question, and it is used interchangeably, but they do mean different things. So it can be looked at as development services being an umbrella term that covers different development types. The main development types that we deal with are primarily subdivisions, but developments can also include unsubdivided lands, cemeteries, membership campgrounds, and timeshares. So it's a broad umbrella that covers all those different areas, but they are commonly used interchangeably.
Okay, so with that, I think we're going to have to define some of the most used terms that you both deal with every day, but that most people don't really understand what they are. So from development services point of view, let's look at the definition of a developer. Jay, would you like to tell us what that is?
Absolutely. And this is defined by statute. A developer is any person who offers real property in a development for sale, lease, or use, either immediately or in the future, or on the person's own behalf or on the behalf of another person. This does not include people whose involvement with the development is limited to listing the property with the development for sale, lease, or use, and those would be considered agents, sales agents or brokers.
Yeah, and just jumping in there, that also includes any of the development types that we previously addressed. So unsubdivided land or cemetery property are considered development. So the term developer refers to anybody offering those property types as well.
Great. And so then let's talk about subdivider.
Well, subdivider is going to be a more specific category. So a subdivider is going to be any person who offers for sale or lease 6 or more lots, parcels, or fractional interests in a subdivision. So it doesn't necessarily need to be somebody who does the actual division of the land, but somebody who is going to offer for sale or lease 6 or more properties in a subdivision.
Okay, let's talk about subdivided land. What does that mean?
That means that it's any improved or unimproved land or lands divided or proposed to be divided for the purpose of sale or lease. Yeah, those are either subdivisions or subdivided lands. They're interchangeable terms by definition.
Okay, so because this is a distinction that most people do not know how to figure out, what is improved and what is unimproved for the purposes of this definition?
So improved properties mean either that there is a building on the property or there will be within 2 years of being contracted by the developer. Unimproved just means any property that is not improved. So that would be your vacant lot where there's no intention of the seller being involved with building on the property.
Okay, great. So one of the things that I know can happen, particularly in Arizona, is we have families who have owned very large parcels for a very long period of time, 100 years or more. And so now the current generation, dad and mom, would like to divide up this large parcel so that each of their 5 kids gets to have a parcel and they're still living there. Is that a subdivision? Do they come under this law's jurisdiction?
It is. It really does depend on the circumstances, but if the end result is that that family member splits their parcel into 6 or more, they do fall under that requirement, even if that isn't their intention to be a developer. So it is a common thing where somebody may have that scenario occur where they do unintentionally create a subdivision.
And in the case of a family, they don't want to be a subdivision and they're not selling it to us strangers. Is there anything they can do that might change that status?
Yeah, so any individual who has property that falls under the subdivision requirements can petition the commissioner for an exemption. And it's these kinds of scenarios that I think we would be able to consider granting an exemption because we understand these circumstances happen without intention. Our primary intention at the department is that we want to just ensure that the public is being protected. So that public report and why it's required is to protect the public. So an individual can make a good case rather to why they should be exempt from that requirement and why exempting that requirement would not harm the public.
Okay, so you mentioned public report. We hear that all the time, and certainly at the department's website, you can find public reports. So tell us what a public report is for starters.
Public report, it's very self-explanatory. It is a report that is public to the purchaser, and this public report contains information that many feel is relevant to aid the purchaser in a decision to invest into that property or not. Many times these reports contain information concerning utility providers, local public schools, other facilities that may be available to the individual in the immediate area.
And jumping in, some other important things in that public report would be property owners associations, as well as what the estimated monthly fee is, and any local taxing districts that the purchaser may want to be aware of, because that's going to impact what they're eligible for financing. It's going to impact what their reasonable costs are going to be. So these are details that a purchaser may find beneficial, and that can be determined on their website by looking on their public database for any subdivisions that have been issued in the past 20 years.
So if I'm living in a subdivision that was built 15 years ago, I can still go and find that public report, that original public report for reference if I need to.
You can.
Right.
That would be on their
I would also throw in the caveat of that the public report, you want to be specific that if you do utilize, you may our public database, you may find multiple public reports for a subdivision. You would want to ensure that your lot is included in a specific public report because the public report may vary depending on different phases or different lots that are being included in that offering.
Which brings up another question. Does the public report have to be updated every so often, or once it's done, it's done?
As long as the developer still has lots that they're offering for sale, they do need to keep that information up to date. If there's any changes to the information in that public report and they still have lots that they're actively trying to sell, it's the developer's responsibility to make sure that they update their public report to make sure that information is accurately updated and provided to purchasers.
So now walk us through the most basic steps of a subdivision approval, so people get an idea that this is not a simple place a form in front of you for development of a subdivision and a few months later they get approval. There's many steps to this. So start telling us about what those basic steps are.
So the first thing when a development is being created is they're going to go through different local approvals. They're going to go through the county to have their subdivision formally platted. And that will also include local approvals from the city or town, depending on where it's located, different permits, different zoning requirements. Every project's going to be different, but there are many local levels that a developer will go through in getting their project approved. And once they have gone through all the necessary local steps, that's when they come to our department for a public report. They will submit a lot of the documentation that they receive from those other agencies and provide that to us along with a draft of what they would like to provide to purchasers that meets our requirements. And then we go through a review on our side to make sure that it is capturing all the requirements of our statutes to ensure that that purchaser is going to be getting accurate and relevant information.
So following up those basic steps, is there one particular area that people who are trying to get a subdivision approved, they just seem to have trouble getting that element included in their application, or if you ask a question about it, it's difficult for them to figure out what is wanted or needed or understand how to submit it? Jay, do you have any questions like that from people?
Oh, yes, on a daily basis. And I would have to say, if anything, one of the more difficult processes for developers to understand are the specific requirements that are going to be needed at different county or state levels. And those might be water documents, sanitary facilities, approvals, and so forth. So we get a lot of questions on those. And as helpful as we can provide the information, typically those are documents that are created outside of our agency. As we are more like the final approvers of the public report, we expect those to have been handled prior to the application process for the public report.
And I think an example is earlier today, you were hosting a development services meeting for people who are interested in attending, and public can attend, or builders and developers, of course. But one of the things that happened is you had a guest speaker today that was ADEQ. And what was he speaking about today that developers and subdividers would want to know about?
He was a representative from the Department of Environmental Quality, and he was speaking to us on recent and upcoming rules that are being reviewed and drafted related to environmental quality, specifically the quality of drinking water and how certain guidelines are going to be changing around that. So a lot of the time was going into some of the nuanced details about what those requirements look like currently and how those changes might be impacted going forward.
So that's an example of something that you're going to be looking for items from that department as part of what you're looking at as completed public report application, correct?
Correct. When we get documentation about sanitary facilities, we review the end product of that, but developers will need to go into the details with the Department of Environmental Quality in order to get that approval. So a lot of these changes that were brought up today are things that may impact their ability to obtain those items in the future, or at least more clarify certain criteria that their department is looking for in determining whether a project is going to be compliant with local and federal guidelines.
Great. So before we leave today, first of all, thank you both for being here, but I want to make sure you each have an opportunity to leave the audience with a thought or an item that you think people need to know and frequently don't, or answer a question that is a frequently asked question, just provide some knowledge that you think people need to part with this podcast knowing or remembering.
I would just really encourage anybody that's looking at buying a new home in a subdivision being issued by a subdivider. I just encourage going through that public report and looking at some of the details. You may be surprised at what you find. It really does hit a lot of different requirements, talking about local services, different restrictions on the property, different characteristics. Just a lot of very useful information, but you won't know unless you go into it. So when that developer hands you the public report when you're looking to sign a contract, you are required to be given that document and have a chance to review it. So as always, we do encourage you to read that. It's for your benefit and may help you make that decision.
And Jake?
Right. Going off with what Tim said, I did want to just emphasize that a public report is a document that is issued to a specific developer who owns 6 or more lots. And this document is typically not found with your typical resales. Wise agents may provide their clients a public report that is found on our public database. You would want to ensure that your client's lot is included within that public report, and if there's any other public reports that may include it that have different information. Typically, like I said, you'll find this information on the public database, but you're always welcome to give us a call at the department as well.
That's fantastic. Thank you both. I really appreciate your time, and this has been very helpful information for everyone, both licensees and the public. Thank you.
Thank you.
Thank you.
I hope you enjoyed meeting Tim and Jay. They are a wealth of information, and as you can tell, eager to help builders, developers, and subdividers as they go through the subdivision and development processes. Licensees. Remember, the department will be requiring particular 1-hour topic-specific CE be completed in order to renew your license beginning in January 2025. These classes are water, firewise, and deed fraud. Several real estate education providers are already providing these courses, so watch for these new offerings. And a quick reminder. The general effective date of new laws passed in the 2024 Arizona State Legislative Session is September 14, 2024. Several laws were passed affecting real estate licensees, their clients, and the public. The department has posted a 44-slide review of laws that will affect the real estate industry. These are not all the laws that may affect you or be of interest to you. So make sure to review all the new laws at azledge.gov. This slide deck review is intended as an aid to licensees and the public and should not be relied on as a complete or comprehensive list of new laws affecting the real estate industry. The new laws cover various topics including HOAs, property taxes, liens and assessments, water, backyard foul, commercial building reuse, fingerprint cards, accessory dwelling units, local zoning, title insurance, residential exclusive agreements to sell, foreclosure, restrictive covenants, and other topics of interest to real estate licensees and the public. Join me next time as we discuss information important to the real estate industry and the public. I'm Liz Recchia. Thanks for joining me today, and remember, keep up, keep current with ADRE.